Okay, we're burning the midnight oil at the beach. Let's go. Remember to leave your house. You don't have to study inside. We're at the beach. So, family court, haven't even touched it. I'm literally just reading these off as fire questions, not just for myself or for anybody else who needs it. I wanted to put them in order and I didn't put them in order. Shit. All right. Whatever. Family Court Act 175, an act or omission which constitutes a violation of the terms of probation may be heard. I don't know if the visual learners could even see this. And the answer is in either the county where the alleged violation occurred or the county in which the order of probation was made. Okay, so again, an act or omission which constitutes a violation of the terms of probation may be heard either in the county where the alleged violation occurred or the county in which the order of probation was made. Okay, let's go to the next one. All right, Family Court Act 154 AC. Which of the following is correct regarding the process of family court? I didn't put the choices. I just wanted the answer. So I'm just trying to knock these out. Can you guys read that? I don't know. Process may be sent into any county in the state. Okay, again, which of the following is correct regarding the process of family court? Process may be sent into any county in the state. Okay, FCA 116CD. This is a long one. Okay, this is a may or must. And I wrote this down because this is very, very, very important. And this one I'm going to discuss because this one I'm a little more familiar with. In appointing guardians of children, except guardian ad litems, and in granting order of adoption, the court may or must appoint guardians and give custody through adoption to persons of the same religious faith or persuasion as the child. Can you tell that I'm farsighted? Okay, so the answer is must. It is mandatory. Okay, so you need to hook up those guardians, except the guardian ad litems, which is the attorney that is assigned to the child. It's must. It's mandatory that they match this child up with someone of the same religious faith. Now, this question gets tricky. Why? Because the little adage on there is whenever practicable. In other words, like whenever possible. But the wording they use is practicable. So if all they have is this, and it says, because the original question said may instead of must, and that's what screwed me up. Those mays and those musts are tricky. So again, I'm going to read it correctly so it stays in your head that it's must and not may. In appointing guardians of children, except guardian ad litems, and in granting orders of adoption, the court must appoint guardians and give custody through adoption to persons of the same religious faith or persuasion as the child. Now, here's the explanation in depth. Okay, the court is mandated by this section to protect and preserve the child's religious faith and must appoint guardians of the same religious faith or persuasion of the child whenever practicable. There it is. The same holds forth for custody through adoption. Okay, so the thing is that if they put may in the question and it's wrong, and you know that it has to be practicable, they can't use practicable because they said may, and practicable basically means may. It means like whenever possible, but not all the time, right? So that may is a substitution, or could be a substitution for practicable. So you're not going to see that in the question because they put may instead of must. And that's where the trickeroony happens. So I don't know if that makes sense, but that's what you just have to know that it's must. And that's it. All right. No more discussion. That one I happen to know, and it's tricky. So let's move on. Let's get over it. Family Court Act 162. This is a true or false. A waiting room with a competent person in charge shall be provided for the care of children brought to family court. I'm pretty sure that this is false. Now, if you read that, you're probably going to be like, what the hell? Again, it comes down to may and must. Let me confirm. And I'm correct. It's false. Because I remember when I get caught, I remember it. So, yeah. So the reason is because, again, it's like whenever it's possible. But the actual term in the code is so far as possible. So this is not literally true. So far as possible is missing from the statement. Tricky. So they have the shall, and you know shall is interchangeable with must. But again, it's so far as possible. All right, let's go on. I know this is supposed to be rapid fire questions, but I'm gonna just call it Q&A. We're gonna keep it because this is it's kind of slow. It's the end of the night. I'm winding down. All right. FCA 117C. The chief admin of the courts may establish on a more separate support parts. Oh, hold on. Let me reread that. The chief admin of the courts may establish, something's missing here, on a more separate support parts in each family court for purpose of expediting support proceedings instituted pursuant to Articles 4, 5, and 5A. And I believe that's true. They have those support parts set up. Correct. I'm right. I like when that happens. I just need to be right on the test. Okay, shall be originated or transferred to this part or parts as they are made known to the court and shall be heard by support magistrates in accordance with section 439. So that was true. Let's move on. Family Court Act 175. An act or omission which constitutes a violation of the terms of probation may be heard in either the county, we already did this one, I have a double card, in either a county where alleged violation occurred or the county in which the order of probation was made. Sometimes I have double cards because I'm just all over the place, to be quite honest. And I'm going back and forth. Sometimes I do it at work, sometimes I do it at home. So, and then I forget the cards and I'm like, I don't even know if I did this one. I'm like, better do it, better to have duplicates than to not have it at all, right? So, okay, Family Court Act 254B. In all cases involving abuse, who shall be a necessary party to the proceeding? Okay, again, in all cases involving abuse, who shall be a necessary party to the proceeding? Okay, so for New York City, it's going to be Corporation Counsel, and outside of New York City, it's going to be the DA, District Attorney. Okay. Okay, Family Court Act 252A. Do volunteer probation officers receive pay from public funds? I would say no. No. No, volunteer probation officer shall be a chief police officer or receive pay from public funds for his or her services. Okay, so no volunteer probation officer shall be a chief police officer, or, so they can't be the volunteers, they can't be chief police officers, and they can't receive pay from public funds for their services. Got it? Good. Let's move on. I get a little stuck it from time to time. Let's see. Family Court Act 249A. The attorney for the child shall appear and may participate in the hearing. True or false? The attorney for the child shall appear and may participate in the hearing. I'm not sure about that one. I'm not even going to answer and embarrass myself. Be careful with may. Ah! Be careful with may. Attorney not only appears but also participates. I didn't answer true or false for this though, but the answer is attorney not only appears but also participates. Okay, so basically it's a must-may thing again. They asked for may, they said may, and it's supposed to be must. And I reminded myself, be careful. Be careful of those mays and the musts. So the attorney for the child, it says shall appear and may participate, but it's actually must participate. And it's saying right here that attorney not only appears, but also participates. So it's saying that the attorney for the child shall appear. So it's must for both. Shall appear and shall participate. Shall appear and shall participate and must participate in the hearing. Attorney for a child, 249A. Okay. Family Court Act 249A again. The court shall make a determination after a hearing at which the standard of proof is by clear and convincing evidence. Okay. The court shall make a determination after a hearing at which the standard of proof is by clear and convincing evidence. The court shall make a determination after a hearing. So they're going to hear it, then they make the determination, and the standard of proof, clear and convincing evidence. Let's move on. Family Court Act 262. Who is entitled to the assignment of counsel if indigent? The respondent in any proceeding under Article 5 in relation to the establishment of paternity. Respondent Part 3. Okay, these are very specific answers. Who is entitled to the assignment of counsel? Oh, okay, I remember this one, if indigent. Okay, so this is a question of remembering, like, which party, whether it's going to be the respondent, it's going to be the petitioner or the respondent that's going to get representation. So if I'm correct, let's see. Yeah, so this is a question that most of the time it's going to be the respondent, and the real crux of it here is that there's only very smaller cases where the petitioner's actually they're indigent and they're going to get that that attorney, that service, that assignment of counsel, right? So I'm going to read all of them and then we'll kind of look at it a little bit closer. So the respondent in any proceeding under Article 5 in relation to the establishment of paternity. Respondent Part 3, custody, and Article 6. Respondent Article 10 or 10A or 10C. Respondent and petitioner Article 8. The parent of a child in any adoption proceeding who opposes the adoption of such child. So those are the people that are going to have that are indigent, that are going to have that they're entitled to assignment of counsel. So it's all of Article 8. And if I remember correctly, with Article 10, I think it's Article 10, Part 8, but I'm not sure if I'm confusing that with another article, so scratch that. I'm just going to read it exactly the way it was given, which is Article 10 or 10A or 10C. So But I think there's something else where it's like specific to 8 and 10 as far as attorney counsel for the petition. And again, a lot of the times, the main part of this is really not just the respondent, but in particular the petition, because it's less likely that the petitioner is going to get that free counsel as opposed to the respondent. So just keep that in mind. Okay, let's move on. Okay, FCA 169. True or false? A court order or temporary order of protection issued under Article 3, 4, 5, 6, 7, 8, or 10 shall be translated in writing into the appropriate language for a party to a proceeding when requested. Okay, it sounds logical, right? Someone requests a translator, so that should like make it happen, right? But that's false. Okay, it's when the translator is actually assigned. When the translator is assigned, then that puts it into motion. It just can't just be, oh, I requested a translator. No, it's when they actually assign the translator. Let me get the exact wording. The translation shall be insured. Okay, there we go. Where the court has appointed an interpreter. They appoint the interpreter and then it's going down. Okay, it's insured. So keep that in mind. It's not just about requesting, it's about appointment of the interpreter. Once the interpreter is appointed, then it's insured. The translation is insured. They got to appoint the interpreter. Okay. Okay. Okay, FCA 115A, the terms mental retardation and intellectual disability are interchangeable, and that is false because one is going to replace the other. Okay, that was amended. So mental retardation was replaced by intellectual disability per amended subdivision 4. Okay, so they are not interchangeable because mental retardation was replaced by intellectual disability. Okay, we have 162A. Restraints on children under 21 are generally prohibited in the courtroom. Okay, key word here is generally. And that would be true because generally. Now, anytime you hear generally, most likely there's going to be an exception. But they're saying generally, it's prohibited, right? Because who wants to tie up a kid and restrain them? Think about it. All right. Who wants to tie up anyone and restrain them? Ouch. Okay. All right. True. Generally. Restraints include handcuffs, chains, shackles, irons, or straitjackets. It's kind of very sad. Very, very sad stuff. An exception to the prohibited use, here it is, of restraint. Here's the exception. Use of restraints include prevention of physical injury to the child by the child. Plus, if child is physically disruptive in the courtroom. So those are the exceptions. Child's physically disruptive in the courtroom, or to prevent physical injury from physically injuring himself. Those are the exceptions. But in general, it's prohibited. They don't want to, put the child in those kind of handcuffs and all of this stuff. What is it? Handcuffs, chains, shackles, irons, or straitjackets. Yikes. All right. I have a criminal card just like that's stuck in here, so why not? Let's, get a little exciting. All right, this is Article 3010, Statute of Limitations. I'm going to repeat this in the criminal video, but screw it. Just throw it in. In calculating above time periods, referencing statute of limitations or, what was it called? Timeliness of prosecution. That's what someone was telling me. The queen of video making. Referring to statute of limitations plus exceptions, the following periods shall not be included. Okay, so period after offense during which defendant was outside the state, or whereabouts of defendants are unknown.
I know, yeah.
In both cases, statute
That's so true. I think
statute of shall not be extended by more than 5 years beyond statute of limitations for that offense. So I'm trying to remember what what statute of limitations this was, whether it was 521. I don't know. Maybe it's good that I just left that at the end. I'll have to look that up. I was just looking to get groups together of things. So anyhow, guys, that was our Q&A, me getting familiar with family court. God help us all. All right, have a good night. It's getting dark here. Toodles.